Hey, hello everyone.
Oh,
All right, is everyone here on Cantu versus Smith, the DC 2210595?
no, no.
Yes,
I'm in the wrong place. I'm George Wells versus Lisa Cohen.
That is set for 10:30. You are in the
Oh, okay.
place, but it's set at 10:30. Your case is not called right now. So, Cantu versus Smith, DC 2210595. Is everyone here in that case?
Yes,
Your
Your
Honor.
Honor.
I'm here for Hernandez versus Arlington.
That case is not being called right now, but it is set for this morning as well. All right. So let's go ahead and start off with Cantu versus Smith, DC 2210595. Counsel, make your appearances.
Your Honor, Stacy Dunlop and Michelle Peters on behalf of plaintiff Laura Cantu.
Good morning, Your Honor. Lauren Green on behalf of the defendants.
And Brian Gillette as well, Your Honor.
All right. Did you get all that, Tony?
Who was the last person? I can't see them. Okay.
Brian Gillette representing the defendants.
Got you.
Okay, let's go and get started.
Good morning, and may it please the court. We're here today on defendant Kyle Smith's motion to compel discovery from plaintiff Laura Cantu. Your Honor, is it okay if I share my screen with a PowerPoint?
You may.
So give me 1 second.
Oh, let me, it is activated, so you can share screen. The screen, do you have a PowerPoint? And you're muted as
Sorry,
well.
I muted myself. I do. I just can't get it to where it's sharing on the Zoom. It's okay. I can proceed without it.
Okay.
So we're here today on defendant Kyle Smith's motion to compel discovery from plaintiff Laura Cantu. This motion is based on plaintiff's failure to properly respond to defendant's discovery. As you may recall from last week's motion for summary judgment hearing, there are limited claims left in this case. A retaliation and wrongful termination claim under which plaintiff is claiming over $1 million in non-economic damages, and a breach of contract claim for approximately $7,500. Defendants are here today specifically for discrete categories of documents that are outstanding. Plaintiff's call log that documents calls and incoming and outgoing text during the relevant time periods, emails and texts, including plaintiff's iCloud backup from her personal cell phone, and plaintiff's social media. Defendants attempted to obtain these documents from plaintiff with no success, nearly 5 months after responses were due and 2 months before trial. Defendant served discovery targeted at plaintiff's claims and damages on September 28th, 2023. And in response, plaintiff promised to produce documents on November 6th, but made no such production. We followed up with a deficiency letter on November 9th.
Can you share screen what they promised, a document that shows what they promised?
Yes, this is in her responses and sorry. Can you see this?
Yeah.
So here, she agreed to produce responsive non-privileged documents on November 6th.
Okay. So nothing specific, just whatever she said was responsive and non-privileged. Is that?
That's correct, Your Honor. However, no production was made on November 6th. We had to send a deficiency letter on November 9th, to which we received no response. We followed up on November 16th regarding the deficiency letter, and in response, plaintiff produced 4 documents on the same date, November 6th.
Okay.
She promised a rolling basis production to which we responded with concern, given that her deposition was scheduled for December 1st, 2023, and there were 3 additional depositions scheduled for December 4th. She made us another small production on November 21st, but this production did not contain the call log, text and emails from her personal phone, or any social media. To be clear, we haven't received those documents to date. We moved forward with her deposition on December 1st, subject to reopening that deposition once additional responsive documents are received. And we filed this motion the day before her deposition, November 30th. We've attempted to confer an additional time on January 12th as requested by this court. We had attempted a hearing on that date. And during that hearing, plaintiff's counsel informed us that they relied entirely on plaintiff to provide responsive documents to us. And indeed, on December 1st, when we deposed plaintiff, she indicated to us that, or she testified that she has no recollection of what she did to respond to defendants' requests. We were able to agree on one outstanding request on January 12th, plaintiff's engagement letter with Mr. Dunlap, but we've yet to receive an engagement letter for Mrs. Peters. Defendants need these documents to defend plaintiff's claims and support our own case, but thus far we've been
So
stonewalled.
let's just kind of break this down. What is currently outstanding that you think they need to produce?
Plaintiff's call log that shows
What does that mean exactly? What is a call log in this context?
Yes, Your Honor. It shows incoming and outgoing texts and calls. Specifically, plaintiff alleges that numerous conversations took place over the phone in her operative petition, and we've requested the call log to show that those conversations indeed took place. We've received no confirmation that any such request has taken place. And
So
no
these
call
are call logs from the
cell
cell
phone.
phone carrier.
Yes, Your Honor.
Is that what you're saying? Okay. That's not a lot of times call logs mean something that's actually entered into a computer or written down. You're talking about call logs directly from. So there were specific phone calls she claimed that she made during in the petition or in her discovery that you want to get verification that she actually made. Is that what you're saying?
Yes, that's accurate, Your Honor.
All right. What dates were those phone calls allegedly made?
There's one phone call on October 21st of 2021. There's an additional phone call on October 21st, 2021 to Tyler Dupree. He's an HR specialist that contracts with our client. And then there is an additional phone call to Tyler Dupree. I believe it's on October 29th, 2021.
And does your client deny that these phone calls took place?
We don't deny that the October 21st, 2021 phone call with Kyle Smith took place. However, we don't have any other substantiating evidence as to her calls or conversations with Tyler Dupree.
So Mr. Dupree denies that he made that this phone call occurred.
We haven't spoken to Mr. Dupree as to whether he denies that those phone calls took
Does he
place.
still work for you, or does he no longer work for your client?
He is a contractor with our client, so he's not an employee of our client.
Okay, that makes a little more sense. All right, response.
Thank you, Judge. Okay, as it relates to the call log, well, first, I don't think that's before you today, Your Honor, because the motion to compel is, I think, on a first set of written discovery requests that were sent by defendants. And this call log issue, I think, is part of the second set of discovery request. And I don't think
Is that correct, Ms. Green?
No, Your Honor, it's request number 20 in the request for production in the first set of requests.
let me, let me check that, but if it is true, that is part of responsive to that, Judge, we have objections that we've asserted relating to that. And let me just see which one you're saying which one was Ms. Green?
Request number 20.
Request for production number 20. Number 20, oh, sorry. Judge, request for production number 20 from Rolling Meadows is all documents and evidence you intend to use to support your contention that one or more of the defendants is the alter ego of any defendant. That's one. The other one from Kyle Smith, 20, is produce phone records from your telephone provider, mobile and landline, providing call logs of all incoming and outgoing calls and text messages for the time period September 1, 2021 through May 31, 2022, and the month in which the EEOC issued its determination letter. And then
so it sounds like the two calls that you're really concerned about are the October 21st and October 29th calls to Mr. Dupree. Is that correct?
We do want to substantiate that those calls took place. However, we'd like to see who else plaintiff was talking to during that time.
You are not going to be able to delve into her entire life because she filed a lawsuit. So I don't mind those two, but is there anything else specifically that's being alleged, phone calls that have allegedly occurred that are relevant to this case, that there's some dispute over whether or not they actually occurred?
Judge, if I might, we've also requested her text messages, especially those contemporaneous with this October 21st phone call. And those are especially relevant because she was communicating with her friends about the phone call and about the potential disruption to her life. And if you recall, one of her remaining claims is for mental anguish damages.
So there's two issues here. One is these two phone calls. So the only two phone calls are the Dupree phone calls that you need verification on, correct?
I believe that's right. Ms. Green, do you?
Right, but Mr. Dunlap, you're going to be required to produce cell phone records. You can redact them regarding these two phone calls involving Dupree. Now let's talk about text messages. No, Mr. Dunlap, we're going to go to text messages.
I just wanted to let you know with my client's ability to be able to do that, Judge. I just wanted to let you know about that.
If she can't do it, if she's like, that's not her current, if that's not her cell phone provider anymore, then you need to sign an authorization to allow them to get that information. It's going to be, by doing it that way, it does increase the chances that they're going to accidentally get additional information. But either you need to provide an authorization or you need to provide those records.
Yes, Your Honor. The issue is that my client, she is not in privy of contract with the person, with the entity that her cell phone is being paid for by her ex-husband. It's part of a family plan. So my client does not have the capability.
Sign an authorization, and if the provider says that's not good enough, I mean, all you can do is all you can do. So I'm ordering her to sign an authorization or to provide those proof of those two phone calls. So, and if for some reason the provider doesn't, that's insufficient to the cell phone provider, then the defendants can compel the cell phone provider. But
okay,
that's she needs to sign an authorization or provide the documents.
Thank you, Judge.
All right, text messages. What are the issues with the text messages?
The issue with text messages is that plaintiff is claiming over $1 million in mental anguish damages. And we know from her deposition, as well as the depositions of Brenna Romine and Yvonne Garcia, that plaintiff is having communications with third parties that speak to the mental anguish standards, substantial disruption in her daily life. We would like to see what kind of conversations that plaintiff was having to indicate whether the $1 million in mental anguish damages that she's claiming are substantiated. We have text messages from other employees that indicate that. Well, let me pause there. Plaintiff has communicated with third parties about the damages that she claims in this case, and we are entitled to substantiate those damages.
I don't disagree with that. So are there text messages?
No, Your Honor. And that's what my response indicates, that after a diligent search, no documents responsive to the request have been identified.
So let me make sure I understand kind of the history on this. So you deposed some people who claimed that she texted them. Was that the situation?
Yes, Your Honor. Plaintiff testified that during her employment, she had a group text message with other employees that she communicated about work issues.
So she testified about it, not these other employees.
Well, the other employees also testified. Brenna Romine and Yvonne Garcia testified that they communicate with plaintiff with some regularity. Yvonne Garcia testified that she communicated with plaintiff after plaintiff's deposition on December 1st and before Yvonne Garcia's deposition on December 4th. Brenna Romine testified that she communicated with plaintiff in the 2 months leading up to their deposition. This speaks to the claims and defenses in this lawsuit, as well as plaintiff's mental anguish damages.
So, Mr. Dillon, how do you kind of explain the discrepancy here? If it occurred, is she says that she's communicated, she has a group text message. What exactly, how do you explain the discrepancy?
Oh, yes, Your Honor. So there were, the testimony, I think, is in two different categories. One, while she was employed with defendants, and then subsequent. As far as the first set, Your Honor, the cell phone that my client was communicating with other employees on was a cell phone of the defendants, and it was returned to the defendants, and they have they have that cell phone. So my client is unable to produce any text messages from that cell phone.
Is that correct, Ms. Green?
Yes, Your Honor. However, when that phone was returned to us, it was wiped, so we're unable to.
Then you can get an authorization from the cell phone company. It's your client's phone. They can get an authorization to produce that if those exist. But
Understood, Your Honor. But
what, Ms. Green? If you guys, Ms. Green, don't interrupt me again, please.
Yes,
If your client wiped the cell phone and destroyed information, that's your client's fault. I don't know if you can get it from the cell phone company or not. Sometimes you can, sometimes you can't. But that's between you and the cell phone company. That makes sense.
Your Honor, if I may, to be clear, my client did not wipe the cell phone. The cell phone was wiped when it was returned to us.
Okay.
And today we're not requesting any communications from plaintiff from her work phone or her work email. We're specifically requesting communications that took place on her personal device, which is why we also requested an iCloud backup, which would potentially have communications that took place on her personal device during the respective time periods.
Okay, so let me tell you how I'll handle this. Any communications, and there's a couple ways that you can handle this. So any communications, what I mean by that is text message communications. You can either, Mr. Dunlap, if you don't have those, if your client doesn't have those communications on her cell phone and can't produce it, then she needs to provide an authorization. The authorization, usually what we do in that situation is have it produced to the attorney. So this case would be plaintiff's attorney. You would review them all, produce anything that's non-privileged, but that's responsive. If there's something that there's unclear about, then there would be an in-camera inspection, and I would go through the text messages. Does that make sense?
Yes, Your Honor. And to be clear, the period of time is from January 1, 2021 and November 1 of 2021. So not any communications from 2022, 23, or 24. And so that's why when Ms. Green was saying about the depositions and communicating with Ms. Yvonne Garcia or Ms. Brenna Romine, that after her termination, that period is not covered by these these discovery requests.
Is that correct, Ms. Green?
There are other requests at issue. Request number 27 asks for communications regarding this lawsuit. I would argue that plaintiff's communications with Yvonne Garcia leading up to and after plaintiff's deposition, as well as Yvonne Garcia's deposition, pertain to this lawsuit.
Yeah, I think that's a fair assessment if it's involving the mental anguish. All right, so go ahead and either have your client search your cell phone to see if there's any responsive documents or text messages. If there's not, then you need to provide an authorization to Ms. Green to allow them to get that. The document should go to Mr. Dunlop first so he can go through them to make a determination of what's relevant, produce the redacted documents, and then if Ms. Green, you feel there's more there, you request an in-camera inspection. All right, and we are running out of time, so anything else?
Just the emails from her personal device.
Same ruling. Same ruling. Anything else?
Plaintiff's social media post. This speaks to mental anguish damages. She testified that she has a Facebook and Instagram account, and we've received no response from plaintiff.
You need to provide access to those accounts, Mr. Dunlop.
Yes, Your Honor. Okay.
So, and whatever she posted, we'll have to determine whether or not that's going to be admissible, but typically it's discoverable. So you need to provide access to that.
Yes, Your Honor.
All right. Anything else, Ms. Green?
No, Your Honor.
All right. What I want you to do is prepare me an order that says that this hearing was heard, that this was heard on February 12th, 2024. Provide that to Mr. Dunlop by the end of the day, a copy of the order. Mr. Dunlop, you're going to have until the morning to review that and make any changes. I need a copy of this order by Wednesday. So the order needs to be submitted to me by Wednesday at noon. And then we will go ahead and review it and we'll go from there. All right. Thank you, guys. You have a great rest of your day.
Thank you, Judge.
Thank you, Judge.
All right, let's go to the default judgment. Tony, are you ready?
Yes, Your Honor.
Tony's my court reporter. Sorry. Tony, are you ready?
Oh, sorry.
Yes, Judge.
Let's go on the record on DC 2315458 Hernandez versus LIH Arlington Park. Counsel, make your appearances.
Yes, Your Honor. This is Attorney Marwell Bailey for the plaintiff, Pedro Hernandez.
All right, let's proceed.
Yes, Your Honor. We filed this motion for default judgment. It took us some time to serve the defendants in this case. They had some properties listed for the registered agents, which were in fact vacant. So we served them at their headquarters in Seattle, Washington, the state of Washington. So service happened on all three defendants by November 15th. We waited some time after that, but nobody filed any appearances. And so we made a motion for a default judgment.
So you provided a copy. I think one of the concerns is that you provided a copy of all the invoices, but no affidavit to prove them up. Is that right?
I don't know. I did not include an affidavit. I can provide that through my client, Mr. Hernandez, who might be on the phone right now, joining us by phone.
All right. Mr. Hernandez, are you here?
Hello.
Yes.
Mr. Hernandez, let me just see real quick, did you actually get service on this case?
Yes, Your Honor. I got service on Rainey Property Management in October, and then the remaining two defendants on November 15th.
Okay, you just provided a bunch of stuff that says it wasn't served. Okay, so I'll take a look at that. All right, do you want to try to prove up the invoices through your client, or?
Yes, Your Honor.
All right, we got to do this quick. Let's go ahead and Mr. Hernandez, are you here? Is he the one whose iPad? Was that him?
Yes. Yes, Your Honor. That's Mr.
Sir,
Hernandez.
please raise your right hand. Do you swear or no? You need to raise your right hand, sir.
Keep it up. Yeah.
Do you speak English?
Yes.
Okay. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may proceed.
Yes, Mr. Hernandez, did you sign a contract with Rainey Property Management to provide services at a property owned by Cathedral Gardens Dallas Partnership LP?
No, we never sign contracts because there's like it's not like a big jobs, like they call me for painting, make ready to get the units ready, but never sign a contract.
So did you come to an oral agreement to provide services to Rainey Property did you come to an oral agreement with Rainey Property Management to provide services at a property owned by Cathedral Gardens LP?
Yes, I did. They follow all the rules for them. Like they asked me to get into net vendor, compliance, and I had to fill up all the paperwork with them and provide all my information, insurance, W-9, whatever they asked me, I did with net vendor.
And then did you provide the services to both through these agreements with Rainey Property Management, you provided services to two different properties, correct?
I did for 3 properties.
But today we're discussing two different properties, one owned by Cathedral Gardens Dallas Partnership LP and one owned by LIH Arlington Park LP, correct?
Correct.
And did you complete the services provided as specifically demarcated in your invoices to them? Did you complete all those services that you invoiced them for?
Yes, I did.
Were you ever paid on any of those invoices?
I don't get paid for any invoice.
So the balances on the invoices remain outstanding?
Yes.
I think that's it, Your Honor. We just, that's the amount outstanding. We did file liens on both of those properties for the outstanding amounts. And we were in communication for quite a while with Rainey Property Management LLC, and it never went anywhere. So Mr. Hernandez hasn't been paid until today, any of the outstanding funds.
Okay, I assume that you intend to offer the invoices as an exhibit in this case?
Yes, Your Honor.
All right, so you need to go ahead and offer them as an exhibit in this case.
I apologize, Your Honor. So we are offering the invoices which were attached to the motion as Exhibit A in this case.
All right, so you need to provide those to my court reporter. Tony, can you go ahead and put your email in the chat?
Yes, Judge.
All right, so make sure you email those today to Tony. Those are going to be admitted as Exhibit 1. Make sure that's marked when you send them, or you can just put it in the email that these are Exhibit 1. And I will go ahead and admit those as Exhibit 1. You provided an order that's on the screen. So so you've asked for damages from defendants Rains Management in Arlington Park LLP. And what is the amount of the damages you're requesting from that entity?
So, Your Honor, with regards to Arlington Park, the outstanding balance on the invoices was $39,462. And
Okay.
then we're asking for pre-judgment and post-judgment interest as well.
Okay,
And
how much
attorney's
how much for prejudgment interest? What is the amount?
the amount for pre-judgment interest. Okay, so for Arlington Park, is $2,663.96 at 5.5% annually.
Okay. $2,662.96. I don't usually
Correct.
put an amount for post-judgment. That's for prejudgment.
That's pre-judgment, Your Honor.
And then what is your amount of attorney's fees?
$4,627.21.
4,600 what?
$27.
And how much did you have it since?
Yeah, 21.
Cents. Did you provide, I don't recall, did you provide an attorney's fees affidavit in the judgment?
I can provide that.
Now, you need to do it now, so we need to have you testify. So, ma'am, please raise your right hand.
Yes, Your Honor.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, go ahead and provide your testimony on attorney's fees.
Yes, Your Honor. I have been working on this case for over a year now from when we first contacted the defendants and reached out to them to try to get them to pay up. The actual attorney's fees started calculating when I drafted and filed the complaint nearly 6 months ago. The case has been taking some time because we had to serve them at multiple addresses. And I do have a breakdown of my attorney's fees by the hour that I can provide the court with as an exhibit.
Are you offering your attorney fee breakdown as Exhibit 2?
Yes, Your Honor.
Exhibit 2 is admitted, assuming those are your billing records, is that correct?
That is correct, Your Honor.
Those need to be emailed to Tony as well today.
Yes, Your Honor.
Billing records are admitted as Exhibit 2. All right, anything else you'd like to say? And anything else you'd like to say about your attorney's fees?
No, that's it, Your Honor.
All right, so for the second defendant, Rainey Property in Cathedral Gardens, what is the amount you're requesting?
The outstanding balance on the invoices is $5,881.
Okay.
And then the pre-judgment interest is $365.99.
$365.99, is that correct? Okay.
That is correct, Your Honor.
And then how much are your attorney's fees, or is it the same?
It's the same, Your Honor.
Okay. Okay. All right. Do you have anything else?
No, that's it, Your Honor.
All right. Court will grant default judgment in the amount requested. I will go ahead and send this to the clerk's office right now. You have a great rest of your day.
You too. Thank you, Your Honor.
All right, you guys
Thank
are
you.
excused. Thank you.
Thank you.
All right. Make sure you send those exhibits in. It's very important. All right, go ahead and let's go to the next hearing, which is Walker v. Miwikuta. Are both sides here on that case?
Morning, Judge. Yes. Attorney Candace Patrick.
I'm sorry, say the name again.
Candace Patrick for the plaintiff.
Okay. And for defendant? Is anyone here for defendant? I can't hear. Is anyone here for defendant? They filed a response, so I assume they're going to be here.
Well, Judge, it's actually the defendant's motion to compel. Plaintiff filed a response.
Okay, sorry. And Mr. Walker, are you here on this?
My client isn't here. No, Judge.
No,
No,
Your Honor,
I'm
I'm
talking
here
about-
on a separate matter.
Mr. Boswell, Mr. Anderson, and are you guys here on this?
Mr. Boswell is with me,
Okay.
I believe.
Rhonda, can you check and see if they still are going forward with this? Maybe the response.
Okay, Jim.
All right. We will come back to your case once we figure out if they're going to show up.
Okay, thanks, Judge.
Who's that? That me? No, it's not me. Can't be me.
All right, we're going now to Wells v. Cohen.
Okay.
Tony, are you ready?
Yes, Judge.
Yes.
Okay. Let's go on the record. Sir, let's go on the record in DC 23-13819, Wells v. Cohen. Counsel, make your appearances.
Your Honor, this is Eric Walker here for the plaintiff, Mr. Wells.
Yes, Your Honor. This is Aubrey Boswell. I'm counsel for Lisa Cohen, who's the defendant in this matter, and I'm located in Dallas, Texas.
Okay. Anyone else here on this case?
I believe that
George
Mr.
Wells.
Wells.
George Wells, I'm here.
Is he representing himself?
No, I'm representing Mr. Wells.
And
And
then-
Mr. Boswell, I believe, is representing Miss Cohen, who is also on the line.
Okay, great. Let's kind of tell me what's going on. I know that there's been a temporary restraining order entered, and I believe there's been a couple of extensions to that. Is that correct?
No, Your Honor, we have a single temporary restraining order.
Okay.
I'm not sure whether one of the requirements of the order has been complied with. The last time I checked with the court's registry, there had been no funds that had been deposited. Just as a little background, this is the case where Miss Cohen was acting as though she was trustee, even though, as we're going to show, she was not trustee, able to hold any type of possession, authority over the trust's funds. And she withdrew all of the funds out of the trust's account, confirmed by a letter from Mr. Boswell. The court, as part of its temporary restraining order, required her to place all of the funds in her possession that she acquired from that account and from a sale of property into the court's registry. I checked last week, I think it was Thursday, and no money had been put into the court's registry, even though the requirement was by last Wednesday at 3 p.m. So that's one thing that I'm curious about, is whether there has been any compliance in the meantime.
Mr. Boswell, what's going on?
Yes, Your Honor. That's correct. No funds have been deposited into the court's registry because the court orders that any funds that are in my client's possession from that account to be deposited into the registry. My client has no further funds in her possession that were received from that account, so we can't deposit anything into the registry.
But I guess we'll find out what happened to those funds. All right, let's proceed.
Okay, Your Honor. Then I call George Wells.
Mr. Wells, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Let's proceed.
Mr. Wells, would you please introduce yourself to the court?
My name is George Fitzgerald Wells. I am the only and eldest son of Thelma and George Wells.
Are you the plaintiff in this case?
I am the plaintiff in this case, yes.
What is your relation to Thelma Wells?
I'm her son. I'm her son and trustee to the estate. Not
What's your
trustee,
relation?
I'm a beneficiary. I'm a beneficiary to the estate.
What's your relation to the defendant in this case, Lisa Cohen?
She is my sister, a beneficiary to the estate.
Now, what relation does Ms. Cohen have to the Thelma L. Wells Living Trust?
What relationship does she have to the trust? She was a second trustee to the trust the entire way things changed. She was a trustee to the trust.
And how familiar are you with the Thelma L. Wells Living Trust?
I'm very familiar with it.
Are your claims in this lawsuit based on that trust and the actions of Ms. Cohen in relation to that trust?
Yes.
Your Honor, I'm gonna do a share screen.
Okay. No, before you do that, wait. Right now, this is on YouTube. I'm concerned about putting something like this on YouTube. Is this something that would be confidential that you wouldn't want to show over the internet? Because I can turn off YouTube if you prefer.
I don't believe so. There's no, I don't believe that there's any information that is going to be that type of privacy interest. Mr. Boswell, do you have?
For example, that sometimes these things have people's social security numbers in them. I just want to, before that happens, I just want.
Yeah,
I have no objection.
To what? To having it on YouTube?
Sorry. I have no objection to it being either taken off YouTube or aired on YouTube.
Okay, Mr. Walker, okay. If at any point you do have a concern, I just want to make sure you knew it was on YouTube. If you have a concern, just let me know, and I'm glad to take it off.
Okay.
Let's go ahead and proceed.
Okay, just a second. Let me get it back up. Mr. Wells, do you recognize this document that's marked as Exhibit 1?
Yes, I do.
What do you recognize this document to be?
This is the living trust that we were under during the duration of her life.
Is this a true and correct copy of the living trust document?
Yes.
And you're familiar with it from observing it, touching it, reading it over the course of time?
Yes.
Have you provided a copy of this to the court reporter?
Yes, I have.
No. I'm sorry. I'm so sorry. Asking your attorney. Have you provided a copy of this to the court reporter?
I can do that as soon as Your Honor gives me instructions on how. I reached out to Ms. Pinson beforehand, and she suggested that I just do a share screen during the hearing.
Yeah, so if this is going to be offered as an exhibit, it needs to be emailed to Tony. Can you see in the chat her email address?
Hold on just a second.
Any exhibits that are admitted need to be emailed to Tony. So,
okay.
Tony, do you see it in the chat, the email address? Okay. All right, let's proceed.
Okay. And I am just about to drop them in, so she will have them.
Yeah.
And I copied Mr. Boswell as well.
Okay, let's proceed. We're kind of short on time, so let's get going.
Yes, I understand. So, Mr. Wells, taking a look at what is page 6 of the PDF, do you see this as being the first main page of the trust document?
Yes.
And who does it identify as the trustee?
Thelma Wells, Elisa Michelle Cohen, and Vicki Wells.
And who is Vicki Wells?
She's my older sister.
Taking a look down here at section 1, who does it identify as the primary beneficiary?
While I am alive and the primary beneficiary of my trust.
Is your mother
while she was alive? Yes. Forgive me, say that again.
And is your mother the primary beneficiary during her life?
Yes, during her life, yes.
And taking a look, we're skipping ahead to page 12. If your mother was ever incapacitated, who was the person who was supposed to take over as trustee?
Vicki Wells.
And then upon death, and this is looking at the bottom of page 13 and top of page 14 of the PDF, Who is indicated here as the successor trustee?
Vicky Wells alone.
And right above that, am I reading this correctly that it says that she would be replacing any then serving trustee?
Yes, that was the arrangement.
Is it your understanding that under this document, regardless of whoever the trustee was during your mother's life, that as soon as she died, Vicky Wells would become the trustee?
Yes, removing all trustees, trust protectors, or anything after. Yes.
When did your mother die?
She died on October 9th, Sunday morning, 2013. I have her death certificate right here. October 9th, 2022.
Your Honor, at this time, plaintiff moves to have what's been marked as Exhibit 1 into evidence as Exhibit 1.
Any objection to admitting Exhibit 1?
No objection, Your Honor.
Exhibit 1 is admitted.
Mr. Wells, I'm showing you what's been marked as Exhibit 2. Do you recognize what this is?
Yes, I do.
What is this?
That is a sale flyer from the estate sale. Lisa Cohen, after the winter storm, I repaired the house myself.
Whoa. He just asked you what this was.
It's a sale flyer from an estate sale from the property at Anglers Ridge.
And how are you familiar with this screenshot estate sale notice?
It was posted on Facebook and Instagram.
Right. And up at the top, it looks like the handle says, I am LESAC. Do you know what that represents?
Yes, that's my sister, Lisa Michelle Cohen.
Is that her picture in the little circle?
Yes, it is.
Would you please tell the court, what is Salon Charis?
Salon Charis is her beauty salon. It's a property they own in DeSoto. I mean, the East Beltline, DeSoto, Texas.
When did you see this estate sale notice?
It was a week before the sale. It was a week, maybe 3 or 4 days. It happened real fast. A week before the sale. I went by there the day of the sale.
Okay. So was that October 1st of which year? Was it 2022, 2023? When was this?
2022.
So was this before your mother's death?
Before my mother's death.
Your Honor, at this time, plaintiff moves to have what's been marked as Exhibit 2 into evidence as Exhibit 2.
Any objection to Exhibit 2?
No objection, Your Honor.
Exhibit 2 is admitted.
Mr. Wells, are you aware of whether an estate sale was actually conducted at Salon Charis around October 1st of 2022?
Yes.
How do you know that?
Because I went by there and my daughter purchased an item for $300. I have a receipt.
Did you ever see any indication from your sister, Miss Cohen, or her attorney that that money was ever received by your mother's trust or the estate?
No.
Your Honor, I'm now showing what has been marked as Exhibit 3. Mr. Wells, do you recognize this document?
Yes, I've seen it.
What do you recognize this document to be?
A deed of trust to Dana Hodges. It's a deed of trust.
Does it just say deed or is it a deed of trust?
It's a deed. It's a property deed. It's a property deed.
How are you familiar with this document?
Our boss will send it to us, myself and Vicky Wells.
Is it your understanding that this is a public record that was filed in the property records of Erath County?
Yes, I was told that it was filed.
What's the date of this record?
12/09/22.
Is that before or after your mother's death?
Before that.
Well, this says December
October,
9th.
in October, this is December. That's December 9th, 22. That was after her death.
So
That's
2 months
her
after.
death. Yes.
At that point in time, based on what the successor trustee provision says in the trust, who was the acting trustee?
Lisa acted as trustee, but she was not. The active supposed to be my sister Vicky was supposed to be the executor, but Lisa acted as if.
So Lisa was acting as if she was the trustee.
Yes.
Does this document on page 2 indicate that Lisa Michelle Cohen represented, at least in this document, that she was acting as the trustee of the Thelma L. Wells Living Trust?
Yes.
Is that your sister's signature on page 3?
Yes.
Your Honor, at this time, plaintiff moves to have Exhibit 3 into evidence as Exhibit 3.
Any objection to Exhibit 3?
No objection, Your Honor.
Exhibit 3 is admitted. I'm a little concerned. This is only set for 30 minutes. You have 7 minutes left to do both sides, so I don't know.
I will be very quick here.
Okay.
All right. Mr. Wells, do you recognize this document that's been marked as Exhibit 4?
Yes.
In Exhibit 4, this is dated the 6th of June, 2023. Do you see that your sister's name, your sister Lisa, sister Vicky, and your name are indicated as the parties?
Yes.
Would you please read to the court? Can you read this? The highlighted
Yes.
section that starts with parties? Would you please read that to the court?
Yes, let me blow up a little bit. Okay, the parties agreed such funds after payment of closure costs, including the balance owed of the existing reverse mortgage liens against the property, shall be paid to the parties in separate and equal 1/3 shares promptly after receipt by the title company.
Is this your sister Lisa's signature on page 2 of this document?
Yes, it is.
Is this your signature on page 3 of the document?
Yes, it is.
Your Honor, at this time, plaintiff
What
moves to have.
did Vicky Wells also sign this?
Yes.
Okay.
She did, Your Honor.
There it is. Okay, all right. And this is Exhibit 4, am I correct?
Yes.
Any objection to Exhibit 4?
Your Honor, I would object to entry of that agreement. This agreement is not relevant. It clearly states it's for the 1934 Lanark Avenue residence and has no bearing on the prior sale agreement that related to a lake house that was at a completely different address.
Response?
Your Honor, this is definitely relevant to what's going on with this case. It's my understanding, Your Honor, that this money should have been put into the estate, that it should have been distributed as part of the trust's funds because the house was part of the trust.
These funds were received by Mr. Wells, my client, Ms. Cohen, as well as Vicky Wells.
Okay, so I'm a little confused. There's 2 different houses, and this is so the deed that we talked about was from a different house, and this agreement involves this. I guess the deed involved the. Let me see. What is the address on the deed?
Yes, Your Honor. This deed right here is Erath County, and this property for the agreement is in Dallas County. It's a Dallas property. So if you notice in that property description,
Okay.
this one is 1934 Lanark Avenue, Dallas, Texas. And the deed is for a property, a lake house property in Erath County.
Is that correct?
They are two separate properties, Your Honor. But we believe that the funds should all be part of the same account that should be distributed to the different beneficiaries of the
But
trust.
this agreement is only about the Lanark Avenue, and I guess that were those funds actually dispersed? Are they in dispute here?
Yes, Your Honor. These funds were dispersed. There were checks written to each of the three. We have a closing statement that that verifies these funds were sent to all three.
I guess what is the relevance of this agreement then if these funds aren't in dispute and it's not involving the property in question?
Oh, it was my understanding that all the funds were not distributed, but that may be an issue for a separate day. It's not, I don't think that whether or not any portion of these funds was distributed is going to be absolutely necessary for this particular hearing, but it is important, I think, to help the court understand the history and the properties that are at issue, that we believe are at issue. And now it's a matter of really, I think, just moving on to the next few to show that.
So you are out of time at this point, so we can reset this temporary injunction. When does the TRO expire?
I believe the TRO, hold on a second. It was signed on the 2nd. So we still have until the end of this week.
All right, I'm going to reset the TRO to 3 o'clock today. So you guys are going to need to re-sign on to, I should have about an hour or so during that time period. So I'm going to go ahead and reset you guys to 3 o'clock and make sure you email the exhibits and already been admitted at this point.
Okay.
All right, we'll see you guys at 3 o'clock. Same Zoom.
Right. Thank you, Your Honor.
Thank you, Your Honor. Thank you.
Thank you, Your Honor.
Okay, let's get to the next hearing. I think our next hearing is on Moser up at Henderson Inc. versus Midtown Development. Is that correct?
Yes, Your Honor.
Yes, Judge, that's correct.
There's a lot of people signing on. Can't even see. Okay, everyone is here on that hearing. Anybody here on any other hearing?
Your Honor, I'm back on the original hearing on Walker versus Mutu, and for some reason I got kicked off the computer as we were announcing.
Okay. This is on the motion to compel.
Yes.
Are both sides here on that now?
Yeah, well, I'm ready whenever you are, Your Honor. I don't know what happened. I was trying to talk to you, and you obviously were not hearing me. And then suddenly, I got kicked out of the thing. I had the feeling that maybe when the other parties that had just finished their hearing got kicked off or got released, that it kicked me off too. And it's doing something weird now. Can you hear me?
I can hear you fine.
Okay. Well, it's something just kicked some of the.
All right, let's go on the record on cause number DC 237918, Walker versus Mutu. Counsel, make your appearances.
Good morning again.
Here for the movement.
Good morning again, Judge Candace Patrick on behalf of the plaintiff.
All right, let's go ahead and proceed.
Your Honor, this is a motion to compel responses to and answers to discovery. And without repeating the entire motion, the court knows very well that any request for discovery the party is entitled to discover any information that is relevant to any part of the lawsuit, including.
Right. I'm really short on time, Mr. Anderson. So what issues do you still need me to rule on? I'm not trying to be rude at all, but I just need to get you to that.
The issue is that the plaintiff objected to every interrogatory and every request for production and the request for admissions, and did not provide answers to most of the questions asked for. For example, on number 1, she made a blanket objection to the answer, and it asked to identify the damages she's claiming, and simply said she had damages to her head, neck, back, but did not specify, like, is she claiming a bruise on her head or a concussion? Is she claiming a crushed vertebra?
Have you guys conferred on each of these?
And Judge, if I could,
Your Honor, Mr. Renwick originally sent a letter to counsel requesting that she withdraw the blanket objections and provide meaningful answers. And all we got was a request to take depositions. And Mr. Renwick responded to that, asking.
All right, Ms. Patrick, what's your response?
Thank you, Judge. Your question to counsel was spot on. The plaintiff's response motion that we filed to this motion to compel is that the parties have not conferred in compliance with the local rules 2.07. I sent over copies of exhibits that were attached to my response. Opposing counsel just mentioned a letter that was sent over to me. But if you take a look at that exhibit, which I believe is listed as Exhibit A, if you don't have it, Judge, I'd be happy to pull it up.
Is it not what I'm share screening? Is this not the exhibit?
I think that's opposing counsel. No, that is my deficiency letter to opposing counsel. That is not.
Okay, different one. All right, sorry.
Yeah, that's not relevant to the current case.
The letter should have been attached to the motion, Your Honor. The local rule does not specify the method for making contact, only that you attempt to contact the lawyer and try to work out your grievances. And Mr. Renwick sent the specific letter listing what, we have got all these blanket objections and no responses at all. In fact, the only document that's ever been produced was with the disclosures, was a one-page medical bill from a place called Mayo Corps. And we had to subpoena the records from Mayo Corps. And as it turns out, the plaintiff was already under treatment for other injuries when this accident happened. And so we're entitled to get information on every prior medical claim to the same parts of the body that the plaintiff is claiming in this case. And they have just stonewalled us from producing anything.
Judge, I respectfully request my ability to respond without being interrupted.
Yeah, Mr. Anderson, you need to stop interrupting. Ms. Patrick, what is your response?
What I was trying to.
Sorry, Your Honor, I didn't realize she was talking. I couldn't hear.
Mr. Anderson, you keep interrupting me and her. I don't know what's going on if you're not used to Zoom, but you need to stop doing that. So, Ms. Patrick.
Thank you, Judge. So what I was trying to convey to the court was that here on the screen is Exhibit A, which was the letter that I received. As you can see, Judge, it's only 3 sentences simply telling plaintiff to basically withdraw her objections. So it's our position that this is not a sufficient conference in accordance with the local rules. The local rules define a conference as a substantive discussion of each and every issue presented to the court. Not only that, Judge, but I actually emailed opposing counsel a couple of days after I received this letter, which I'll put on my screen now. It was sent to the court reporter. It's Exhibit B. And in this email, I'm asking for deposition dates, to which opposing counsel responds and tells me that I cannot take the deposition of the defendant until they receive a response to their written discovery. My response to them was, if you can see here, in order to have a fruitful conference regarding your objections, you'll have to specify grounds for believing the objections are improper. So, Judge, it's my position that we would love to conference with opposing counsel, but sending us a 3-sentence letter basically saying withdraw your objections it's not a way for us to fruitfully conference. And in Dallas County, it has always been the position of the court that the parties should be encouraged to confer with each other and play nice when it comes to resolving discovery disputes. So defendants' motion to compel is simply premature. They have not complied with the conference rules. They sent me that one little rinky-dink letter telling me to withdraw my objections as if they're trying to bully the plaintiff. That's not how litigation works. So I am at this time requesting that the court do a 30-day reset so that the parties can properly confer and try to resolve the discovery issues first. And
Ms.
then
Patrick, let me how I deal with this all the time. I do it exactly the same way in
Sure.
every case. So what I do is I'm going to send you guys into a breakout room. You guys are going to confer about each and every request. I agree with you that was not proper. That was not a sufficient conference, but I do that. What I always do, if you're in person, I send you back to the conference room. If you've ever seen me give any CLEs, I'd say this exact same thing. So you guys are going to go into a conference room. You're going to confer on every single thing. Mr. Anderson, I encourage you to actually confer and not just say withdraw all the objections and then that's it. That's not a conferral. And I'm going to send Ms. Castillo, who's my intern, and she's going to make sure that she doesn't have any ability to rule on anything, but she's going to report back to me to make sure that you confer on every single one. Okay, Ms. Castillo? All right, we're going to put you guys into a room. You're to confer on every single request.
Thank you, Your Honor.
Mr. Anderson and Ms. Castillo. And Ms. Castillo, you need to take notes about this, okay? All right. Any questions before I send you to the breakout room?
No, Your Honor.
And if you don't finish by 11:50, then you'll have a lunch break until 1:30.
Thank you, Your Honor.
All right. And you'll come back at I'm sorry, at 1:30. Yeah. Any questions about that?
no, Judge.
No, Your Honor.
All right. You should have gotten the link. All right. Our next hearing is just a busy morning. Is Moser up at Henderson versus Midtown Development? Is anyone here on that case?
Yes, Judge. This is James Mendez for the defendant, Midtown Development.
All right, Tony, let's go on the record on DC 15659. Moser up at Henderson versus Midtown Development. Counsel, make your appearances.
James Mendez for defendant, Midtown Development, Inc., Judge.
Danita Glenn for plaintiff Moser up at Henderson Inc.
Steve Hutchinson for SK2 Architects.
Oh,
Ann Parrish
Mr. Heath,
for
you're muted.
Ann Parrish for Serrato Construction.
Bob Kaminsky for Randy Hendricks and Randy Hendricks Custom Homes.
And Judge, we have one more, Mr. Stephen Heath, who I believe is speaking, but his mic must be muted. So Judge, we have two matters before you today. We have Midtown individually, their special exceptions to plaintiff's first amended petition. And then we have an amended opposed joint order for continuance of the trial date in this matter. And I'll start with the motion for continuance. So the movements, which encompasses the defendants and the third party defendants, are seeking a continuance of the trial date for two purposes. So the first purpose is so the parties can mediate this matter. And the second is so that plaintiff has adequate time to amend their petition, which they requested in their response to Midtown special exceptions. So I'll start with the first point. So sometime in October of 2023, plaintiff's counsel circulated an email to all of the defendants and third party defendants seeking dates to conduct mediation at the beginning of 2024. And they offered some dates in January and some dates in February. Now, on that day, counsel for Midtown sent a response to plaintiff and said that we weren't available for the February dates, giving various reasons such as trials, hearings, and arbitrations. After we gave plaintiff notice of that, they went ahead and set mediation with Steve Nelson, who mediated this the first time. And that mediation is apparently set for February 20th, so next Tuesday. So the reason that Midtown.
Let me just ask this. Is this an agreed motion for continuance or not an agreed motion?
Plaintiff is opposed, Judge.
All right, so if this is not an agreed motion, given the age of the case, I am not granting it. So let's get a mediation set. So is your issue that you can't go to this mediation next week?
Yes, Judge, because we, along with plaintiff's counsel, are set for a bench trial with Judge Eric V. Moyer on that date. And to plaintiff's credit, they've been trying to coordinate with Mr. Nelson's office in order to get alternate dates, but unfortunately, he doesn't have any availability before the March 26th trial.
So we're going to send you to Judge Pfeiffer to mediate your second time. So we're going to go ahead and get that done. He's very experienced in this type of case. So let me go ahead and contact his office and see if we can't get you a date.
Yes, Judge, understood.
Usually they can get you in pretty quick. If there's an issue, then we'll figure it out. But he's an expert in construction law cases. This is a construction law case, right?
Yes, Judge. Thank you.
This is Karen. May I help you?
Hey, Karen, this is Judge Hoffman in the 68th District Court.
Yes, sir.
So we're trying to set up a mediation with Judge Pfeiffer and just wanted to see what dates he has coming up. When do you guys, your trial setting, you have a little bit of time on this one. The trial setting's on March 26th, and I just denied the continuance on it. So they need to get a mediation set. When do you guys want to look at? What dates do you guys all have available?
Judge, if I can, I think I can, at least for the...
you need to speak up a little bit.
Yes, Judge. Can you hear me a little better now?
Yeah.
Okay.
Sorry, there's a lot of parties on this one, Miss James, so this may take a second, okay?
Okay.
I apologize. Why don't you give us some dates starting about anything he has like 2 weeks from now, because you have a trial next week, is that right, with Judge Moyer?
Yes, Judge, February 20th.
So let's look at anything after February 27th.
All right. I have, are we looking for a full day?
I imagine a full day given the number of parties, is that right?
I'll defer to plaintiff's counsel on that one, but I imagine it would be a full day.
Yeah, there's like 8 parties or something on this. So yeah, they'll need a full day. You can't even introduce yourself at a half day with this many parties. So a full day if he has any.
The only full day he has before the 26th of March is the 12th.
March 12th?
Yes.
That's the only full day. Wow. Okay. March 12th work for everybody?
March 12th works for plaintiff.
Okay.
Judge, let me see. So Judge, counsel for Midtown is set for trial on that date in the, I'd like to give you a.
I don't know what, I don't know something wrong with your sound, but I can barely hear. You said you have a trial setting that day?
Yes, Judge. Here, it might be helpful if I just go ahead and try and plug in some headphones. That might.
What about the remaining defense counsel for March 12th?
Your Honor, Serrata Construction also has a trial set for that day.
And is it going to go or not going to go? Do we know?
Well, we're asking for continuance, but so we're hoping that they will grant the continuance.
Anybody have, besides the trial setting issue, anybody have any problems with March 12th or with Judge Pfeiffer?
No issue with Judge Pfeiffer. Judge, our only issue is that we have trial set for March 11th through the 15th.
Your Honor, I'd like to point out that Mr. Mendez's office does have several different counsel available and several different counsel assigned to this case. So I would imagine that they could work something out.
Is that correct?
So that at least one person.
Judge, the lead counsel in this case, they're both going to be tied up in the Buckner trial with Judge Moyer on the 20th.
You have 2 trial settings coming up with Judge Moyer. There's one next week and on the 20th.
No, Judge, we have a trial setting with Judge Moyer on the 20th. And then I don't think we have another trial setting that week. The issue we have is March 12th. We have trial set for the 11th through the 15th.
And okay, and you have we're going to go ahead and just set it on March 12th. You're going to be required to provide counsel. If you have multiple counsel, you can send one of them to this. It's going to be with Judge Pfeiffer. Rhonda, are you there?
Yes, Judge, I'm here.
Go ahead and we're going to order there to be order this to mediation with Judge King Pfeiffer on March 12th. And then let me give you the cause number on this real quick. It is DC 21. This is for you, Karen.
Okay.
DC 2115659. It's Moser up at Henderson Inc. versus Midtown. Are all the parties correct on the system? Because there's a lot of parties. There's Danita Glenn, Kurt Eliason, John Kanarick, Jason Jung, James Mendez, Kurt Eliason, and Robert Louis Kaminsky. Are those all the right parties? And then there's third-party counsel Stephen Heath, Ann Parrish, and Steve Hutchison. Are those all correct?
That sounds correct, Judge.
I'm trying to bring it up right now. It's searching for it.
Okay.
Okay, I have Danita Glenn as the plaintiff with Moser, Kennefic, and John Menendez. I have John Kennefic as Midtown.
Yes.
Kurt Ellison as Kid K
Yes.
and Midtown.
Yes.
Moser. Those are the only ones I'm showing. So I'm sure there's going to be a motion in here that will show more of the attorneys.
Yeah, let me and Karen, let me give them your number in case there's any issues. Karen is schedules for Judge Pfeiffer. It's 214-316-8144. I don't want to keep long. So you guys are you have her number and the media. That's all we need you for today, Karen. Thank you so much.
If one of the parties could actually send me a docket sheet that has it written out a little bit more, that would be very helpful.
What is your email address?
It's K James. It's my first initial and last name.
K James
At Burden.
At Burden
-ADR.
-ADR.com.
Your Honor, I'll take on that task and have my paralegal send the sheet with all of the parties' contact information to Ms. James.
All right. Thank you so much. All right. Thank you, Karen.
Right. Thank you.
All right. Thanks. Bye-bye.
Bye.
Okay. You said there was a second issue you wanted to chat about?
Yes, Judge. So we also have Midtown special exceptions to plaintiff's pleading. And these special exceptions concern 3 causes of action pled by plaintiff: negligence, negligence per se, and their claims under the DTPA. Now, I guess starting with the negligence per se issue, plaintiff agrees that they need to amend their petition because in their negligence per se pleading, among other issues we have with it, the one that plaintiff acknowledges is that in pleading negligence per se, they haven't identified any sort of statutes, ordinances, anything like that, which they allege.
That would be required under negligence per se pleading. So I agree with that. Ms. Glenn, when can you replete that?
By the end of today, Your Honor.
Okay. What are the other 2 issues?
So then the other issues are, to be candid, Judge, a little bit more profound. So starting with the negligence per se issue, in their pleading, or sorry, starting with the negligence issue, my apologies. In plaintiff's pleading, they make these general allegations against the defendants, just the defendants as the whole, for negligence in things, as they put it, supervising, constructing, renovating, repairing, maintaining, and or other things with the premises. But they don't make any distinctions between any of the defendants, and they don't make distinctions between any of the defendants' actions that either give rise to a legal duty.
I apologize. There's an issue involving the conference. I need to join that for a second. I'll be right back.
Yes, Judge.
Okay. Can you hear me okay? Let's go ahead and start over.
Yes, Judge. So last we left off was on the negligence issue.
Okay.
So in plaintiff's negligence pleading, specifically in paragraphs 26 through 27.
Go ahead and share screen that.
Yes, Judge. I will go ahead and pull that up. Let's see.
Okay, there you
go. Judge, can you see my screen?
Okay, yeah, that's, you said 26 and 27?
Yes, Judge. Let me, oh, that's a little bit too close.
Okay.
Can you see that okay, Judge?
Yep, see, great.
All right. So the issue that Midtown takes with paragraphs 26 and 27 is that it doesn't make any distinctions between any of the parties, what the actions of any of the parties were, which is important for us to understand and get fair notice of the basis for which they claim that we either had a duty or breached that duty. And while plaintiff refers to defendants generally, their allegations of actions are equally as vague or imprecise. So in addition to claiming that defendants generally did something, they then allege supervised, directed, managed construction, designed, provided materials, installed materials, facilitated repairs, maintained, inspected, and
No,
or
I get it. That's too broad if there's nothing more specific. So is there something more specific, Ms. Glenn, in the document that details what each party did?
No, Your Honor, but the rules do allow a fair notice pleading.
I understand the fair notice pleading. This is not fair notice. And so I'm going to order you to replead within 7 days to go into more detail on what each defendant did. So you have 7 days to replead that. So you need to replead 26 and 27 and replead as to what you claim each defendant did.
Understood, Your Honor.
All right. What else do we have?
Yes, Judge. And actually, just to piggyback on what you've said for plaintiff to have an additional 7 days, part of the request sought in our special exceptions is any leave that plaintiff has to amend their pleadings, that the defendants also have commensurate leave in order to file responsive pleadings, additional special exceptions if necessary.
Is there, is the pleading deadline passed at this point?
Yes, Judge. And we're also coming up on the summary judgment deadline, which is February 17th. And if plaintiff has commensurate leave to amend their pleadings and we don't, we run in danger of filing motions for summary judgment on pleadings that will be or have been already superseded by subsequent pleadings.
Why didn't you bring a special exception before the pleading deadline passed?
Judge, to be candid with you, I don't have a good excuse with it. I filed this special exception and I made a request to my office to have it heard, and just that request wasn't met. But
yeah, I'll if you want me to, I'll allow them to replead within 7 days. I'm not going to reopen all the pleading and the summary judgments and everything else. If you guys had a chance to bring a special exception for the pleading deadline, do you want her to replead or not?
Judge, if it is the case that Midtown won't be provided additional leave in order to respond to these.
I'm not saying that. You can file a motion for leave. I'm just not granting it right now.
Understood, Judge.
So if you want a motion for leave to provide additional pleading, or if Ms. Glenn wants to agree to allow you to replead, I don't have a problem with that. I'm just not going to do a blanket because you waited, your side waited to bring this until after the pleading deadline. I'm not going to just blanket allow you to have additional time to plead. So,
and Judge, just to be clear, like when you say allowing a blanket time to replead, would the court be more amenable to allowing leave if Regis requests 7 days, much like how plaintiff is getting 7 days? Would the court be
She's
agreeable to
not
that?
getting 7 days. This is not a situation where she's requested it. You're requesting that she replead. So I'm not giving her, if you don't want her to replead, I'm not going to require it. I think this is a little unclear. I think
I
you
agree, Judge.
probably should have brought a special exception earlier. But you can't just use this as a way to just reopen the pleadings because you guys waited on the special exception. So I'm allowing her to I'm going to require her to replead if you want her to. Do you want her to replead?
Yes, Judge, I do.
She's going to have 7 days to replead. If at that point you want to reopen pleading, you can file a motion for leave and I'll take a look at it. If Ms. Glenn agrees to it and opposing counsel agrees to it, I don't have a problem with reopening it, but I'm not going to make some kind of blanket decision. Maybe I'm not clear about this.
Judge, I think I actually may have been unclear myself.
You've been perfectly clear. I understand. Let's move on.
I'm sorry.
You've been perfectly clear. I understand. You can move on.
No, Judge, I think I actually was unclear as to your question regarding the pleadings, because you'd asked about the pleadings deadline, and I think that I accidentally conflated that with the dispositive motion deadline. The dispositive motion deadline has not yet passed. That deadline will be, I believe, February 17th. And so I'm not essentially requesting that the pleadings be reopened. I'm just requesting that the deadline to file dispositive motions is extended. It's not yet closed. And that's where I was unclear.
Yeah. You have a dispositive motion deadline to file the dispositive motion by February 17th or have it heard by February 17th?
File by February 17th, Judge.
All right. So, Ms. Glenn, what I'm going to do is I'm going to allow you 3 days. You're going to be required to replead this within 3 days. So by this Thursday. And if you guys want to file a motion for summary judgment based on that by February 17th, then you can.
Okay.
All right. Anything else today?
No, Judge, that's all.
Okay. Go ahead and prepare an order on that. Make sure the order says that this was heard on February 12th, 2024. Provide that to Ms. Glenn. Ms. Glenn, I'd like you to sign off it as the form if you can, and get that to me no later than Wednesday morning at noon.
Yes, Your
Okay,
Honor.
guys?
Understood. Thank you, Judge.
Anything else, guys?
No, Judge. May we be excused?
You may. Good luck with Judge Pfeiffer. I've heard he's a very good mediator, and you guys have a great rest of your day, okay?